All right, good morning, everyone. We'll go on the record at this time with State of Minnesota versus Nicole Mitchell. It's court file CR 24654. And we can note appearances for the record that we have Ms. Mitchell, who's here with her attorneys, Mr. DeCray, Mr. Ringstrom, and Mr. Keller. We have Mr. McDonald, who's here on behalf of the state. As we all know, the matter comes before the court today for sentencing. The court is in receipt of a pre-sentence investigation in this matter, has read and reviewed the same. Mr. McDonald, I trust that you've received a copy of the pre-sentence investigation. If so, do you have any additions or corrections?
Your Honor, not necessarily addition or correction, but something that the state believes was a slight omission under the recommendations for conditions. We will be asking the court for an additional condition of no contact with Carol Mitchell. That was not in the PSI.
And we'll have comments for sentencing, as you're aware, but thank you for bringing that to my attention. Mr. DeCray, any errors or omissions in the PSI?
None, Your Honor.
Okay. All right. I've also received and read the sentencing memorandums from both the state and the defendant, as well as the many letters of support of Ms. Mitchell and the other submissions filed for purposes of today's hearing. Mr. McDonald, the PSI identified that Carol Mitchell's son, Mr. Kuhl, and Ms. Muxfeld would be providing victim impact statements today. Is that correct?
Yes, Your Honor. Carol Mitchell also submitted a written letter that she would like me to read today.
Okay.
And I did speak to Mr. Kuhl and Ms. Muxfeld, and neither has any objection to media coverage during their statements, Your Honor.
All right. Well, this will be the time then for the victim impact statements. And so I don't know if they care to use a podium, Mr. McDonald, or if they're going to be seated next to you.
Your Honor, just for consistency, I think everyone will utilize the podium today.
Okay.
And we would like to start with Mr. Kuhl, Your Honor.
All right. Good morning, Mr. Kuhl.
Good morning. Your Honor, a bit closer? All right. Your Honor, I am submitting this victim impact statement to provide the court with a deeper understanding of profound and far-reaching effects the home invasion committed by Nicole Mitchell on April 22nd, 2024 has had on our lives. While it was difficult to express the true depth of the emotional and psychological repercussions we have endured, I hope that by sharing our experience, the court will fully recognize the gravity of the harm inflicted. My mother, Carol Mitchell, enjoyed a life of relative stability, peace, and a sense of security within her own home of 40 years. It was her sanctuary, a place where she felt safe, comfortable, and at ease. She enjoyed the community and neighbors, but also valued privacy and cherished her independence. Mom's early Alzheimer's was diagnosed shortly before the sudden loss of her husband, Rod Mitchell. The grief over losing Rod had a hard impact on Mom's diagnosis, but she was still able to be independent and feel safe in her home. We saw encouraging signs that Carol was recovering cognitively from the impact of losing Rod. Then, Nicole Mitchell broke into her home, forever destroying that precious sense of safety, peace, and trust, and impacting Mom's disease in a way none of us could have anticipated. The aftermath of the home invasion brought a storm of emotions: shock, disbelief, confusion, and overwhelming fear. It wasn't just the knowledge that her stepdaughter Nicole Mitchell had entered her private space without consent that left Mom feeling exposed and violated. The experience of waking to a noise in the night and stepping out of bed in the dark onto a live body was absolutely terrifying, as it would be for anyone. She relives the break-in repeatedly, haunted by the fear of it happening again. Restful sleep has grown scarce. Anxiety and dread often wake her in the night and stay with her all day. For Carol, everyday activities such as leaving the house unattended, answering the door, or even being alone now stir up anxiety and fear. This was not the case before the break-in, even with her experiencing early onset Alzheimer's. She has developed symptoms consistent with post-traumatic stress. Post-traumatic stress-induced sleep disturbances, heightened vigilance, persistent unease, and a continuous fear of Nicole returning. The break-in has affected me and our entire family. Mom has become more cautious and withdrawn, hesitant to trust others or depend on them for help. Conversations that used to bring comfort and laughter are now tinted with worry and sadness as we all grapple with the impact of the trauma. There's nothing I can do to take away Mom's emotional anguish from the home invasion. And in that regard, it leaves me feeling helpless as her son. Carol's friends and neighbors, a great source of support in the wake of the break-in, now have their lives and routines disrupted as they lovingly step up. Nicole's social media posts and her lawyer's statements to the media expose Mom's Alzheimer's to the Nicole has, in effect, taken Mom away from me sooner than she would have slipped away from me otherwise. Although some time has passed since Nicole broke into my mother's home on April 22nd, 2024, the effects will last forever. Nicole may get a fresh start, but Mom find whatever sense of renewed peace and safety is possible. Each step forward, no matter how small, is a victory and a testament to Carol's resilience. My message to Nicole Mitchell. Nicole, I want you to understand the consequences of your actions. The pain and fear you caused extends well beyond April 22nd, 2024. You abandoned trust and decency. You abandoned trust and decency. You knew how to contact me. You knew the proper channels, but instead you did something incredibly selfish and cruel. And then you doubled down and victimized Carol all over again, leading up to and during the trial. More cruelty. I hope you take real and full accountability for what you have done. Be honest with yourself about how your victimization of Carol would have hurt your father. I believe that God forgives us and can help us grow even from our gravest mistakes. I hope you will use your skills, your education and life experience to help others you encounter in this next path that you are on. Your Honor, I am grateful for the opportunity to share these perspectives with the court. I hope that it helps provide insight into the full impact of Nicole Mitchell's crime. Thank you for your attention and your consideration.
Thank you, Mr. Cool. Mr. McDonald.
Your Honor, next I would like to read Carol Mitchell's victim impact statement. Better? Nicole Mitchell, my stepdaughter, broke into my home, destroying the egress window she used as her entrance. This was shortly after my dear husband, her father, passed away suddenly. This break-in was not an act of concern for me, as she has declared, and the video of her as she was arrested is proof of that. The proof starts with her breaking into my home around 4 a.m., destroying the egress window she used to get in, and disguising herself by dressing entirely in black, from the top of her head to the tips of her toes. just like a burglar. And the police have a video of her in that outfit. She had parked a block and a half away. She then broke in and at some point laid on the floor next to my bed. She was attempting to open the drawer under the bed where she knew I kept a pistol. Rod loved to tease me about that pistol, and she learned all about it from that. I believe that her opening that drawer, which was directly below my sleeping spot, was what woke me. I was startled awake and stepped out of bed, only to step on a live moving body, which I tried to grab out of instinct. This body in black then jumped up and ran with me following. I don't know how I got so brave, but from what I could see in the dimness, I thought it was a teenage boy. Then this person ran down the hall into the kitchen and then continued to run down into the basement. And I grabbed the landline phone in the hall and I dialed 911. Those wonderful policemen were there so fast. They caught the burglar. They then took that person away in the police vehicle. They called out and let me know it was Nicole Mitchell. Now that was definitely not a care call. I believe Nicole planned it all carefully and had expected to find my pistol, shoot me, put the gun in my hand so it would eventually be found. It would look like a suicide. She must have felt that all would believe that I chose to leave this world and join Rod out of my deep grief, and she thought she would inherit everything. The fear that Nicole created when she broke into my house has not left me. I am afraid for my life. I moved out of my, quote, paid-for house and moved into a high-security 55 and over, residents only, at a cost of $1,700 a month apartment building. I only recently moved back into my paid-for home after installing a complete security system that helped me feel safer. But the fear is still there. Every time I leave my home for shopping or whatever, I have to check every room, closet, or storage area to feel safe again upon returning. I even changed the locks, and I installed the security system. My neighbors are wonderful, and they watch over me too. But my life has completely changed. The fear is with me to stay. I am flabbergasted by Nicole's actions, and I'm concerned about her mental health. What she did is not a normal reaction at a time of a lost loved one. She went completely off the grid out of pure greed. My life will never be the same. Fear has moved in with me to stay. How could I ever trust Nicole again? Statement of Carol Mitchell.
Thank you, Mr. McDonald.
Your Honor, we would like to end with the statement of Pam Muxfeld.
Okay. Ms. Muxfeld, you may come forward.
Good morning, Your Honor. I appreciate this opportunity to provide you with a victim impact statement to further provide you with a better understanding of how the actions of Nicole Mitchell have been frustrating, mentally and emotionally challenging, and at times overwhelming. In the early morning hours of April 22nd, 2024, I was awakened by a text message from my aunt, Carol Mitchell. I started to read the text message and thought she was telling me about a dream that was beginning to sound like a nightmare, only to realize it was real and it had just occurred at her house. Carol was awakened around 4:30 a.m. for some unknown reason. She got out of her bed and stepped on a body that was lying on the floor next to her bed. The body, dressed in black, then jumped up and ran towards the basement without a word. Carol then grabbed the phone and called 911. Nicole made no effort to calm or console Carol. She ran to the basement to hide or escape. Actions that certainly fit the criminal intent. Carol has now lived in fear for the past 17 months due to the actions of her stepdaughter, Nicole Mitchell. Imagine going to bed every night and worrying about every sound that you hear. What Nicole Mitchell did to Carol that night is not what you do if you care about a loved one. Nicole, you clearly stated that you had grave concerns about her well-being due to some recent updates on her medical records that you accessed without anyone's permission. You knew she was diagnosed with Alzheimer's before your dad passed, and you also stated that you felt that she was dealing with some paranoia. Yet you chose to break into the house rather than take other measures of reaching out to her or any of her family. To try to get sympathy and to selfishly build a case for yourself, you knowingly announced Carol's health issues publicly through news releases and social media. This has now made her a vulnerable adult with an easy prey for other criminals who take advantage of senior citizens. I feel the actions you have shown towards Carol since the passing of your dad have been cruel, despiteful, and heartbreaking. I know it wasn't a hidden fact that you were jealous of the relationship that they shared during their 45 years they were together. The life that Carol and Rod built with each other was special, and it was theirs, not anyone else's to take advantage of. Nicole, you were a very educated person and have made huge accomplishments with your life, and Carol was so proud of you. She shared those accomplishments with all of us, and we were proud of you too. So I'm not sure if it was the greed or the grief that caused the turn of events on April 22nd, 2024, but either way, you cannot go back and change it. Since that night, we now have much anger towards your actions. They were not the actions of a rational, well-educated, and caring family member. They were actions of a criminal dressed in black and holding a covered flashlight, and you should have consequences. It saddens me to know that Carol now lives in fear daily, and the stress of all of this has not helped slow down the progression of her Alzheimer's. If anything, I feel the stress of this horrible ordeal the past 17 months has taken away precious time and memories. Every delay and news broadcast alert has further victimized Carol and made her life more difficult. With the help of her family, Carol has now had to make life-altering changes since all this has happened. I know it's a proven fact that people with Alzheimer's often rely on their routine as a source of comfort. Having a daily routine helps them to know what to expect, and any sudden disruption in routine or to experience a stress may cause symptoms to get worse. I see how the stress of this break-in has now made Carol more cautious, uncertain, and shows more levels of anxiety when facing things that come so easily before. Nicole, the decision you made on April 22nd, 2024 will forever be a reminder to all of us of how people with power think they are above the law. Making poor life choices comes with consequences. Your premeditated actions were cold-hearted. You chose to make Carol a victim. You have shown no remorse in any of your actions, yet feel entitled to a lesser charge because of what the current charges can do to your future. You had a great career and a promising future. Did you ever think what this would do to Carol's future? In closing, I only can hope that Carol can continue to have the quality of life that she deserves. She has her family and close friends that watch out for her. Help her, and we will all continue to be here for her. I hope you take full accountability one day for your actions and admit the truth of why. I also hope that you never have to experience this type of mistrust from your own children. Thank you, Your Honor, for giving me the opportunity to share my statement and letting my voice be heard as you find due diligence with the sentencing.
Thank you, Ms. Muxville. Comments as it relates to sentencing, Mr. McDonald?
Yes, Your Honor, may I utilize the podium?
You may.
Your Honor, I'm going to try to be concise, but I'd like to start with a few things that were noted in the defense's memorandum or brief. First and foremost, Your Honor, the fact that there's a page or half page devoted to continue to try to frame this as a welfare check is disingenuous, Your Honor. The jury soundly rejected that argument, and this court should too. The defense also cites to the fact that the defendant stole nothing and, quote, her lack of stealing means everything. Your Honor, she was caught in the act. This was always a burglary about intent to steal, not getting away with valuable items. The fact she didn't get away with anything means nothing. Mr. DeCray also cited 3 generic other burglary cases and appeared to try to focus on the value of items. Again, Your Honor, the first-degree burglary statute doesn't discriminate based on how valuable items taken are or the intent to take those items. So, Your Honor, the attempts to somehow differentiate Nicole Mitchell's first-degree burglary from other first-degree burglars is disingenuous. She is no more important, nor is she less culpable than other first-degree burglars. Next, Your Honor, in their memo, they quote said that the defendant, quote, never played the politician card. Your Honor, she not only played it, she flipped it off the top of the deck and paraded it throughout this case. 2 days after her release, Exhibit 116 at trial is her official Senate release. And I'm going to read just a few excerpts from this. Excuse me. Senator Nicole Mitchell, 47, DLFL, does not intend to resign. Halfway down. It saddens me that some people are attempting to use a tragic family situation to score political points. I am confident that a much different picture will emerge once all the facts are known. So that's at the start of the case, Your Honor. And as the court is well aware, in the middle of the case, she asserted a seldom used legislative privilege, Minnesota Statute 3.16. It was absolutely the law and her right, let's be clear. But it caused a delay of this trial of 5 months, and it's a privilege that she could have waived had she wanted to, and had she not wanted to play the political card. Then, Your Honor, you have the victim impact statement that wasn't read today but filed in the court from Mr. Jim Gelbman, one of Ms. Mitchell's former constituents in her district. He detailed about the secret town hall meeting that was arranged, except for the details of that meeting were only shared with those who were sympathetic to her situation after she was charged. And then finally, Your Honor, we have, even in the defense's own brief, asking the court for sympathy and citing to the, quote, end of her promising political career as a reason why the court should do something different than what the statutes call for. So let's be clear, Your Honor, she's played the political card throughout this case. Your Honor, in their memorandum, they would have the court believe that Ms. Mitchell is suffering more than the average defendant. If you peel back the layers, it's simply not true. If you look at her military career, there's no evidence she was ever court-martialed. There's no evidence that she lost her pension. She retired. She retired on her own terms. And yes, it's possible there may have been things coming down the pike had she stayed in, but she retired. Again, her Senate career, she resigned. Granted, it wasn't until after she was found guilty in this case, but she resigned on her own terms. There was also some talk in their memo about her children, Your Honor, and I agree, it is a sad, tragic consequence. But it's no different than any other offender who has children and who are facing incarceration. Plus, Your Honor, this should have been part of her calculation. These are the same children that she arranged childcare for when she drove 220 miles in the middle of the night before breaking into Carol Mitchell's home. So everything cited by the defense in their brief, Your Honor, is a natural consequence for the defendant having committed this crime. Next, Your Honor, there was an excerpt, excuse me. There was a portion of the memorandum devoted to stating, Nicole committed a crime, but she's no criminal. They attempt to continue to portray the defendant as, quote, a peaceful burglar. But what they fail to recognize, Your Honor, is that breaking into an elderly, vulnerable adult's home in the middle of the night is inherently dangerous and scary. They also ignore the amount of calculation from this incident. The packing of the bags, the tools brought with, the 220 miles traveled in the middle of the night, the outfit that she chose. The brief is devoted, Your Honor, to try to convince this court that this defendant is somehow more important, more polished than other individuals who've made mistakes and come before the criminal justice system. Finally, Your Honor, talk about lack of remorse. Again, the memorandum continues to try to perpetrate the same lies that were attempted at trial and that were rejected by the jury. After almost every hearing, and especially after the trial, there were interviews, statements given by the defense in this case. But before today, Your Honor, not once, even after being found guilty, has Ms. Mitchell apologized to Carol Mitchell. This will be a classic story, Your Honor, of being sorry that she got caught, but not sorry for what she did. And we can glean that from the litany of special requests contained in the sentencing argument made by the defense, Your Honor. So, Your Honor, our request here today is for the court to sentence Ms. Mitchell to 21 months in the Commissioner of Corrections and to stay execution of that sentence. Why a stay of execution versus a stay of imposition? Well, Your Honor, Minnesota Statute 609.583 guides the court in terms of sentencing a first-time offender of an occupied dwelling. And it says, quote, "The court shall presume a stay of execution." And I submit to Your Honor that they have submitted nothing that warrants a deviation from this presumption. We're further asking the court to place Ms. Mitchell on supervised probation for up to 5 years, asking the court to specifically order that she have no contact with Carol Mitchell in addition to the other recommendations contained in the PSI. You're asking the court to impose a $1,500 fine, a $75 surcharge, and a $10 law library fee. We are asking the court to order that the defendant serve 6 months in the Becker County Jail, or 180 days. Why? Because this is the law, Your Honor. It's covered by Minnesota Statute 609.582, Subdivision 1A. By my research, 609.582 has existed since 1990, 35 years. One point of clarification, Your Honor, we do not object to work release. My memorandum was objecting to some form of community work service in lieu of any jail time. So there was just a slight misunderstanding there. Now, Your Honor, the defense has asked the court to stay any jail time while they appeal this Roush decision. Let's be clear, Your Honor, Roush is not the starting point here. 609.582 Subdivision 1A is the starting point. It's been on the books since 1990, has never been overturned. What Roush did is simply, when one court deviated from that, the Court of Appeals said you can't do that. It's a legislative rule. It's a defined statute dictating a minimum sentence, and the courts should not deviate from that. That's what Roush said. Your Honor, in regards to their request for the state jail time while she appeals whatever they're attempting to appeal, she cannot meet the first prong, that it's not frivolous or taken for delay. What point of law are they seeking to challenge, Your Honor? The only thing they're claiming is that their client is too important to serve jail time. That's not a novel legal concept that needs flushing out by the Minnesota Supreme Court. 609.582 sub 1A has existed for 35 years. Again, the only purpose of the request is to delay incarceration for Ms. Mitchell. Your Honor, there was a comment in their brief that jailing Nicole while she challenges Rouse precludes her any benefit. The vast majority of offenders who choose to appeal their sentence face incarceration. She's no different than the 95% of other individuals who might wish to appeal their conviction. Again, another example of this defendant claiming to be too important to face a consequence. Your Honor, as a county attorney, I am a firm believer in second chances, forgiveness, rehabilitation. But the people who deserve these breaks are ones who display accountability, remorse, or both. Ms. Mitchell has displayed neither of these traits throughout this case. There are statutes that dictate this sentence, Your Honor, and on behalf of Carol Mitchell and the citizens of this county, the state is merely asking that the court follow them. Thank you, Your Honor.
Thank you. Mr. McDonald, just a question here to clarify,
Yes, Your Honor.
if you want to go to the podium there, just so we have that on the record in the mic. You mentioned that the position as it relates to work release, that you have no objection to work release. The request is to serve time in Ramsey so that her job is located there. Will you clarify the state's position as it relates to that?
Sorry, Your Honor, I did gloss over that important point. Your Honor, our position is that 609582 subdivision 1A speaks to serving 6 months in the county workhouse. It doesn't say the county that's most convenient to the defendant or the county that's requested by the defendant. It says the county workhouse. To me, to the state, that means the county where the offense was committed. So we would object to that request, Your Honor.
Okay, thank you for clarifying. Mr. DeCray, comments as it relates to sentencing?
There's one part from the state's argument that I want to remind the court as it listens to our argument and as it considers our sentencing memorandum. And what Mr. McDonald said was, quote, "It is absolutely the law and her right." He was referring to her filing a motion to continue her trial during session. And he said it was granted because it's absolutely the law and her right. Nothing we ask in our sentencing memorandum is any different than that. The state is going to try to convince you that we are asking for preferential treatment because Nicole Mitchell was a public official, anything like that. Let me be very clear. I would be making these exact same arguments no matter who my client was, the publicity of the case, or anything like that. It is my job to zealously advocate for every opportunity, which is absolutely the law and my client's right. I agree with Mr. McDonald for that point only, and I ask that guides the court as it makes its sentencing decision today. There are two questions that we have asked this court to decide with respect to Nicole Mitchell's sentence. First is whether Nicole's convictions should be reduced from felonies to misdemeanors. As our memo makes clear, there are two ways for the court to do this. First is a stay of imposition, which is essentially a dispositional departure. What this is about is who Nicole is. In that regard, Nicole's allocution is everything today. It is very important for the court to understand who Nicole Mitchell is, why she did what she did, and whether she's sorry for her actions. A stay of imposition is asking the court to drop down from a felony because this conduct is so atypical from the defendant's conduct their entire life that they deserve a break from this court. Her allocution will make that the final linchpin for the court to decide. We laid out all of the reasons why we believe she qualifies for a stay of imposition or a dispositional departure, but the final piece is for Nicole to stand up and tell you everything that she's been waiting to tell this court. The second option to reduce her convictions from felonies to misdemeanors is a durational departure. That's about only what Nicole did. And so what Nicole has to say, while it's important for this case, for the state of Minnesota, for the victim in this case, that does not factor into the analysis as to whether or not a durational departure is appropriate here. Mr. McDonald made his arguments why he does not believe that this first-degree burglary, this theft-based first-degree burglary, is lesser in kind than other theft-based first-degree burglaries. We've made our position clear. This court is well positioned to decide if the conduct of the burglary itself is less than the heartland conduct of first-degree burglary, such that a durational disposition a durational dispositional departure, a durational departure is appropriate. We believe that it is, and as the court makes that determination, what Nicole allocutes to is not relevant. It's relevant for a stay of imposition, not a durational departure. One last thing I'd like to add about this, which we made clear in our argument, Nicole fosters children. She has fostered children for many years. One of her children was a foster child. The way that we read this statute, and I think this is for one last factor for the court to consider, if she gets a stay of imposition, it will be a felony on her record until her probation is done. We read that to mean that if a person gets a felony conviction on their record at any point, and it's one of the enumerated convictions in the statute, it will preclude her regardless if it becomes a misdemeanor eventually. So the only way for the court to allow Nicole to be a foster parent again would be a durational departure. If it weren't for this, I would argue that it's more appropriate for a stay of imposition, because then there would be a felony conviction on her record. It would be the scarlet letter we discussed in our brief. It would be temporary and not permanent, but it would be there and it would be a mark for good. But because of this issue with the foster statute, the foster care statute, I leave it to the court to decide whether or not it wants to have that collateral consequence spring to life. I note that it will just only not happen under a durational departure. Unlike the state's argument, there is no rule or statute that says that you can't get these requests if you go to trial, or that they're only available pre-trial. There's no rule or statute that says it doesn't apply to a public official, or public figures, or cases that have publicity. We are not asking for favorable treatment. Like the ruling you made in our motion to continue this case when she was in session, we are simply asking for you to apply the law if you believe that it applies to Nicole's case. We have identified the laws, the guidelines, and the departures that we believe apply. We are not asking for favorable treatment. It's absolutely the law and her right to ask for that, and that is why we have made those arguments. The second question for this court to decide is the logistics of Nicole's sentence. Again, there are two options. The first option is to hold the sentence in abeyance while she challenges State v. Roush. The second option is to not do that and have her begin to serve her sentence right away. There are three elements for the court to consider with whether or not she should be able to hold her sentence in abeyance while she challenges State v. Roush. That the appeal is not frivolous, that during the appeal she won't run or not show up when it's done or commit any crimes, and the risk that she would serve her sentence before the appeal is complete. The state takes issue with the first part. I trust that the court has read Roush, has read our briefing, and understands that this is not a frivolous challenge. It is the perfect case to challenge this. It is a statutory interpretation question. It is whether the two statutes work together to make it so that there is never an opportunity for a judge to step outside of the mandatory minimum and to sentence a defendant under the normal Minnesota guideline statutes and sentencing guidelines. This is one case from 2011. It has not been appealed. It has not been reviewed. As we have made clear, no other court has ever looked at this because it is the perfect situation where an individual has a small sentence, and so unless the court is willing to step in under Rule 28, they will never challenge it. The Minnesota Supreme Court is a different court than it was before. They are the ones in the best position to say what the law is. There should be an opportunity for this ruling to be reviewed and to see if the same analysis of Roush from an intermediary court holds weight before the Minnesota Supreme Court. The only way that happens is if we hold the sentence in abeyance while she argues it. It's important to note that no matter what the court does here, as the law currently stands, she's being sentenced to 6 months. We're not asking the court to ignore Rausch. I think that's very important. We're asking the courts to apply Rausch and then delay enforcing it while we see if Rausch remains good law. And what does that mean if we play that all the way through? If Rausch were to be overturned, we would simply come back here another day, and we would then allow this court to have its hands no longer tied by statute to determine what the appropriate sentence is here. The guidelines say the sentence should be stayed and there should be no jail time, but this court would have the opportunity. We are not asking for favorable treatment. We are asking to review the case and the statutes to see if they still apply. If they do, her sentence springs into life and she serves it. If they don't, we come back here and this court still has the opportunity to decide what it wants to do in the case, just like it does with every single other defendant. If anything, this is less preferential treatment to Ms. Mitchell because it doesn't allow the court to use its reasoned judgment and all of the considerations and its time on the bench to determine the appropriate sentence. 6 months. That's it. This is the problem, in my opinion, with mandatory minimum sentencing. There always should be an opportunity to listen to these arguments and understand that we are sentencing individuals and individual people. We would like an opportunity to see if Rausch and the statutory interpretation is still correct before the court's hands are permanently tied. If the court believes that it is not appropriate to invoke Rule 28 and allow the sentence to be stayed while we challenge it, we ask what defendants across this state ask all the time. Number one, to serve their sentence close to home. That would be Ramsey County. As we noted in our sentencing memorandum, the vast majority of time, counties are happy to accommodate that request because it saves them money. That's a factor that usually plays a significant role here. If the individual is allowed and willing, they can serve close to home. That is not an atypical request. The law allows it. It is not preferential treatment. Mr. McDonald says that they are not opposed to work release, but the reason the court asked that question is because that is a chicken-egg problem. She doesn't have a job here. She hasn't looked for a job here. If the court asks her to serve her sentence here, she will effectively be barred from work release. I don't think it's intentional by the state to be clever in that way, but it's a hollow gesture to offer work release if there's no practicality that it can happen. If the court is serious about her sentence being served here, it should remand her in a month so she has an opportunity to find employment here. But the purpose of employment is for continuity and to begin right away to pay restitution, and because we know that almost every person comes back out of jail. Work release is meant to succeed while you're in jail, not knock you off of your track as best as possible, and to take advantage of it. And the vast majority of the time, what I've experienced it, courts are ready and willing and want to offer work release because it shows the person is trying to turn this page. Practically speaking, the only way that happens is Ramsey County. We ask that the court order she be allowed to serve her time at Ramsey County. As we noted in our brief, and I'll be honest, this is the first and only real favorable treatment request we asked for Ms. Mitchell. And that is to allow her to report within 15 days so that she can get a paycheck from her new job so that she can qualify for work release. There's no statute for that. Everything else I've talked to you today about either has a statute, a rule of criminal procedure, or a sentencing guideline that backs it up. This is whether the court believes that if she should be allowed to participate in work release, then it has to give her the tools to qualify. Ramsey County has been very good when I've spoken to them It's normally 2 paychecks that they ask for. They have agreed to allow it to be 1 paycheck. If she can get a paycheck earlier than the 2 weeks that we identified in our brief, she will turn herself in early. There's precedent for that. She gave herself 2 weeks to resign from office. She did it in 1 week because she was done. We asked for 15 days. If she gets no check by then, this court has done its duty if it believes she deserves it, and she will go in and she won't qualify. She found a job being one of the most famous felons for the last couple months in Minnesota. That was no easy task. She has an opportunity to get a paycheck to qualify like any other defendant who gets sentenced to jail. We ask that the court allow her 15 days, no more, to report to jail so that she can qualify for work release. I always struggle ending these arguments. I don't envy judges having to make these decisions. I've only been on one side of the V, as we say, my whole life. So it's very easy for me to always want to view it in terms of what is best for my client. This is a very complicated situation. And I hope that whatever happens, there will be resolution with this family. I don't know if there will be, but I do know, no matter what the state says, and no matter what you've heard, that Nicole Mitchell is a very good person. I have come to know her very well for this time. This is not who she is. This was an enormously stupid mistake that she made. But she is not irredeemable. She is not out for preferential treatment. I made many mistakes in my life. And I watched many people say things about me that I've heard said about her. And it's very hard to be able to knock down, dust yourself off, and try to do something again. My consequences were no near as bad as what Ms. Mitchell has faced and is likely going to face. So I always have empathy for defendants in these cases. I also have empathy for the victims. I ask that you weigh everything. Use your time as the county attorney, as a prosecutor, and as a judge to determine where does this sentence fit with respect to everything that you've seen. And do not use the publicity or any arguments that this is made because she was an elected official. These are the laws, these are the statutes that are allowed. We would not be doing our job if we were not arguing this way, and she deserves these things. She deserves to be punished, but these arguments that we make are grounded in the law. They're permissible. We're not pulling at the edges. It's appropriate. And we ask the court makes the determination that we outlined in our sentencing memorandum and I summarized today. Thank you.
Thank you, Mr. Ducre. One question. In your sentencing memorandum, or your sentencing position as it was titled, you referenced the employment and that the first paycheck would be September 30th.
I did a 2-week calculation because in all of my jobs that are not, it's usually a 2-week pay schedule. I believe that Ms. Mitchell has spoken to her supervisor and they think they might be able to process one in 1 week. But that's where I came up with the 14-day period, just because that's the standard. I didn't reach out. I can do that and get back to the court. That's not probably a great answer right now in the moment, if that's the thing the court is concerned about, but that's where that number came from.
So there hasn't been?
She has worked at least 3 or 4 shifts at her job, but she has not received a paycheck yet. The 16th was her first day. When I spoke to my client, they normally get paid in 2-week cycles. That is why we thought she had just missed. The 15th was the last pay period, so she missed it by 1 day.
All right. Well, it's important here. So you haven't reached out to her place of employment to get a specific response or an answer to what date or what day it would be that she would receive that paycheck?
I have not heard from them specifically. When I spoke to my client, it was every 2 weeks on the 15th and the 30th.
Thank you, Mr. DeCray. All right, Ms. Mitchell, is there anything you wish to say before I impose your sentence?
Your Honor, I deserve to be here today. The things said and the harm I caused are real things. And I completely abide by whatever you feel is fair. It's wrong to hurt anybody, but especially, in my opinion, someone you love. And I can go through a list of horrible decisions that I made. But there's two that stick with me. And the first even if I had been in and out, I broke into her home. I was selfish. I was worried about my own feelings and a possible confrontation or hearing something that might have hurt me, and I did something ridiculous and illegal and selfish. And the second thing is, once I was there and she woke up and bumped into me and felt me and started to yell, I thought she knew it was me and I was a coward and I ran. And I deserved whatever she would have yelled at me. Whatever she had to say at that point would have been 100% justified. And by handling things that way, I didn't go back. I didn't check on her. I was only thinking about myself. And it contributed to the eventual paranoia, which I absolutely believe is true. If in the middle of the horrible wrong I was committing, I would have thought about her and her state of mind and not my own. Even if this outcome was exactly the same, I think it would have made a difference in the paranoia and fear I know she believes. I cared about her and I wanted to help. And when things were down, I thought about myself instead. And then made continuous bad decisions from there. I tell my kids that by the time you have to say you're sorry, it's kind of already too late. You've already done something. That you need to be very careful with your actions and your words. Because sometimes there are things that are so big you can't take them back. You can't fix them. And this is one of those situations. I don't think there is anything I can say or do that will ever be big enough to repair the harm that I've done. And I wish I could be saying this all in person, and I understand why I cannot be. And that's my fault too. All I can say is I hope she finds it in her heart to forgive me someday. I don't think I probably deserve it. I still love her. My kids still love her. If she ever wants a relationship again, that door is open. But I messed everything up. And I did something wrong. And I will work on being a better person, and with whatever is decided here today, trying to use that time to reflect on how I can possibly repair this. Very sorry. Thank you, Your Honor.
Thank you, Ms. Mitchell. All right, folks, we're going to take a 15-minute recess, and then I'll return and deliver the sentence. We're in recess.
You heard it there, a recess in the sentencing of Nicole Mitchell before this sentence is handed down. We'll obviously bring that to you live as that sentence gets handed down, but we're going to talk a little bit about what we've seen so far in the courtroom with Nicole Mitchell. Of course, Nicole just addressing the court, ending it by saying that she's sorry. She admitted to the wrongdoing, saying that it was wrong. She called breaking into her mother's home a selfish act is the word she used, also calling it illegal, which it was. She was found guilty. And so now all that's left to do is the sentencing. The judge said that there's going to be a 15-minute recess, and then we'll be back to it. So we are going to go ahead and take a quick break here. Again, stay with us. In 15 minutes, we're going to be back live with the sentence handed down on former Minnesota Senator Nicole Mitchell. Stay tuned right here to Valley News Now. We'll be back here in about 15 minutes. Just want to provide an update for anyone still with us here on Valley News Now as we await the sentencing of Minnesota State Senator Nicole Mitchell. They're on a 15-minute recess right now, so we will get to that as soon as it becomes available from the courtroom. We're just waiting for that recess to be over. Want to kind of run down what we're expecting to see here. Again, we heard from the defense this morning and Nicole Mitchell herself apologizing, admitting that what she did was, quote, the word that she used was selfish, and saying that it's illegal. Again, she was found guilty of first-degree burglary for breaking into her stepmother's home. That trial was back in July. Sentence expected to be handed down here in the next few minutes. Now, what both sides are arguing here, the prosecution has said that Mitchell must serve at least 6 months in jail or in a workhouse. They mentioned those two possibilities there. The defense has actually, this was filed just before, I think on Friday, just before the weekend here, asking the judge to consider some options, including putting her sentence on hold so she can search for appeals, or reducing her felonies down to misdemeanors. Those are options that the defense has placed on the table. Again, the prosecution arguing that Mitchell must serve at least 6 months in jail. It all comes down to the judge at this point. We're going to see what that sentence looks like when we go back to the courthouse here in Detroit Lakes momentarily. The maximum sentence for burglary in Minnesota, no more than 20 years in prison and or a fine of no more than $35,000. So I don't imagine we'll hear either of those today, but we'll see what happens. We're going to go ahead and go back onto a little bit of a break here. We'll be back out to Detroit Lakes for the sentencing of Nicole Mitchell once court is back in session.
Ms. Mitchell, you are before this court having been convicted by a jury of your peers of burglary in the first degree, intent to commit theft of an occupied dwelling, and possession of burglary tools. Everyone deserves to be safe and feel secure in their home. Where we live is our sanctuary. The home is the one place people can and should feel completely safe, secure, and private. Which is why intrusions to this highly valued space is an attack to one's safety and privacy. As we have heard today and throughout the trial, your intrusion to Carol Mitchell's home has caused her to fear for her personal safety, caused a lost sense of security, unnecessary anxiety, and continued emotional distress. The Minnesota burglary statutes are clear and unambiguous. Minnesota Statute Section 609.582, Subdivision 1, Paren A, and Subdivision 1A identify that a person convicted of the statute must serve 180 days in jail. In Minnesota Statute Section 609.583 directs that a court shall presume for disposition a stay of execution. A stay of imposition may be granted only if accompanied by a statement on the record of the reasons for it. And this court is not persuaded to sentence below the 180 days mandated. Nor am I persuaded today to deviate from the presumption by the reasons offered to stay imposition of your sentence. You have experienced collateral consequences in your personal life, but this is the result of your decision to commit this burglary. There is no legal authority that allows or instructs this court to weigh those consequences and reduce the criminal sentence mandated by statute. You have requested that your sentence be stayed to allow you to challenge State v. Roush's interpretation of Minnesota Statute 609.582. Rule 2802, Subdivision 7 of the Minnesota Rules of Criminal Procedure states, if a defendant is sentenced to incarceration, a court must not grant release pending appeal from a judgment of conviction unless the defendant establishes several specific factors. That the appeal is not frivolous or taken for delay, and that there are no substantial risk the defendant will fail to appear after the appeal, or that the defendant is likely to commit a serious crime, intimidate witnesses, or otherwise interfere with the administration of justice. Establishing these factors does not entitle a defendant to release pending appeal. It merely sets the baseline of what is required before a court may even consider granting such a request. As State v. Roush makes clear, there is no ambiguity in Minnesota Statute Section 609.82, Subdivision 1A. A person convicted of burglary of an occupied dwelling must be committed for 6 months to either the Commissioner of Corrections or the workhouse. When the legislature uses the word must, it intends for a statute to impose a mandatory condition unless another intention clearly appears. Here, no other intention appears. State v. Roush has been controlling precedent for 14 years, and there is no reason for this court to believe it would be overturned. It remains good law today, and this court is bound to follow it. Under State v. Roush, the 6-month jail sentence for first-degree burglary is mandatory. And this court is not persuaded that there is merit to your argument to stay sentenced to appeal. The request to hold your jail sentence in abeyance pending this appeal is denied. Nicole Mitchell, if you'd please rise. As to count 1, I hereby adjudicate you guilty of the crime of burglary in the first degree in violation of Minnesota Statute Section 609.582, Subdivision 1, Paren A. It carries with it a maximum penalty of 20 years imprisonment and payment of a fine of $35,000 or both. Therefore, as punishment, you are hereby committed to the custody of the Commissioner of Corrections of this state for a period of 21 months. However, execution of this sentence is stayed and you are placed on supervised probation for 5 years, subject to all the rules and regulations established by the Department of Corrections, the 10 standard conditions of probation, which include follow all state and federal laws, tell your probation officer within 72 hours if you have contact with law enforcement, if you are charged with any new criminal offenses, if you change your address, employment, or telephone number. You are to cooperate with the search of your person, residence, vehicle, workplace, property, and things as directed by your probation agent. You are to sign all releases of information as directed, and you are to give a DNA sample when directed. You are not to possess any firearms, ammunitions, or explosives. And you may be seated as I go through the rest of your sentence, Ms. Mitchell. And you'll be required with these additional conditions. You are ordered to serve 180 days in the Becker County Jail. I will authorize Huber work release privileges. Since you are employed, I will allow you to serve your time at the Ramsey County Jail so that you may keep your job and have income to pay potential restitution and fine. You must pay the cost of your confinement in the Ramsey County Jail. The Becker County taxpayers will not be responsible for the cost of your incarceration. So that you may qualify for work release at Ramsey County, I will allow you to report on or before 6 p.m. October 1st, 2025. I took that as being the first day after September 30th, which is you were to receive your first paycheck from employment, and that was from the sentencing memorandum. However, Mr. DeCray has identified today that there's some uncertainty as to when you will receive your first paycheck. So if you cannot meet the requirements and you don't have a paycheck by October 1st, you are to report the first day that you do receive that paycheck. However, I will not go beyond the 15 days as identified. So if it happens to be the 2nd, that is the day that you report, but not beyond the 8th of October, which is the 15 days that is requested. And if you don't have that, you cannot qualify, then you are to report to the Becker County Jail no later than 6 p.m. on that date of October 8th. You must coordinate serving your time with both the Becker County Jail and the Ramsey County Jail facilities in advance. The Becker County Jail will need confirmation of your arrival to Ramsey County. You need to make sure that you're coordinating with those two jails to have this accomplished.